meeting, you're in the wrong place. You can go somewhere more fun. If you wanted to be here, you are in the right place. The meeting is open to all. And there's more information about what we're talking about today available on our website at www.pima.gov/415 under the current rulemakings tab. All participants are currently muted. There will be time at the end for questions and comments, and you'll be able to unmute yourself then. We'll have instructions. If you need assistance during this presentation, please email the facilitator. That's Sarah Height. Sarah, if you can raise your hand. She's reachable at sarah.height@pima.gov, and that will appear in a number of places throughout the presentation. Please note that this meeting is being recorded and transcribed as well. Our meeting agenda is fairly brief. We're going to start by explaining what the proposed rulemaking is, and we're going to go through the definitions in the rules and also some plain language. We are going to discuss why PDEQ is doing this rulemaking, what the impacts are of the rulemaking timeline, how to submit a written comment, and then we should have time for questions, and we will have a closing remarks screen. My name is Abigail Okrant. I'm the Rules Manager at Pima County Department of Environmental Quality. Sarah Height is an environmental specialist who has helped with this presentation. He'll be facilitating this meeting. Also on this call is Scott DeBias, who is PDEQ's director, Judy Tovar, our deputy director, Kristen Randall, who's showing up as Kristen Landrum, who is our air permits manager, and Mark Rogers, who is the assistant engineer for air permits, who knows a lot of things. I think that's it for staff. Again, if you need assistance during this, please email Sarah Height. That'll be all the way through the end as well. If you're trying to make a comment or a question and it's not working, please email Sarah. Did I skip a slide? Yes, I did. How did that even happen? Okay. What is the proposed rulemaking? The proposed rulemaking will remove 4 sections of the Pima County Code in Title 17. These are sections that create affirmative defenses for permitted stationary sources whose emissions exceed the permitted amount, either due to an emergency circumstance beyond the source's control, or as a result of an exceedance during a startup, shutdown, or malfunction. These are the sections of code. Again, they are listed on our rulemaking page. There are hyperlinks there, and this at the bottom is the website that you can look at the whole entire Pima County Code for free. There are 4 sections to apply to major sources, which are known as Class 1 sources locally, and 2 apply to minor sources. And there's 1 of each for an emergency circumstance affirmative defense and 1 for a startup, shutdown, malfunction defense, affirmative defense. I pulled the definition of emergency circumstance from the sections of code where it's written out. Please note that this is part of a much longer rule, but I just wanted to make sure for this presentation that everybody was clear on what an emergency is in this context. So in this context, an emergency is any situation arising from sudden and reasonably unforeseeable events beyond the control of the source that require immediate corrective action to restore normal operation and that causes the source to exceed a technology-based limitation under the permit due to unavoidable increases in emission attributable to the emergency. And then there's a clause there that an emergency does not include non-compliance to the extent caused by improperly designed equipment, lack of preventive maintenance, careless or improper operation, or operator error. This would constitute an affirmative defense for an action, that's a court action, for non-compliance with the emission standards. Again, this is part of much longer statutes. If you're interested in reading the whole thing, they are linked on our website at pima.gov/415. I've also pasted the language here for emissions exceedances that could occur during malfunction or startup and shutdown. Again, the full text is available on the website and also in our notice of proposed rulemaking, which is linked on our website, where we show the full text with the redactions. A malfunction that would constitute an emergency defense would be a malfunction that occurs in spite of the operator engaging in various acts to try to prevent that. And that is not in this part that I pasted here, but it's in the full text. And an affirmative defense is available for startup and shutdown if the emissions are in excess of the limitation from the permit. And again, the operator has complied with all of their various reporting requirements. In plain language, an emergency circumstance is something that happens directly to a permitted facility that would either cause the emissions to increase or cause emissions control equipment to fail. It does not mean a changed outside environmental or other circumstance that might prompt a facility to choose to act in a way that would exceed emissions. We've had questions come up about this, so we have an example here. To the left is our fictional example slide in which lightning strikes a forest, causes a forest fire. And in response to this forest fire, an energy generating unit chooses to run beyond its permitted limitations, therefore having excess emissions in response to attempting to provide more power to fight the fire. That's not an emergency circumstance because the lightning did not happen directly to the energy generating unit. They made a choice. On the contrary, if lightning struck the same source, causing a fire and causing excess emissions, that might be the kind of emergency circumstance that is contemplated under the affirmative defense rules. This was outside of their control. It was not their operation choice or operator choice. What is an affirmative defense? This is also very important. Affirmative defenses apply only in judicial, so court, or administrative, which is hearing board cases. When people think about affirmative defenses in common terms, the one that everybody knows is self-defense in a criminal case. So self-defense is an affirmative defense in a criminal case for assault or homicide. The person being charged isn't saying they didn't do it, but they're saying they were justified. An affirmative defense is one that, when successfully raised, blocks the judge or hearing board from ordering relief against the party. For these affirmative defenses in the code as they are written, the source would have to prove that it took measures to prevent and then control the emissions exceedance, documented and reported all of this to PDEQ, but the emissions exceedance occurred anyways due to the emergency or the startup shutdown malfunction event. Why is PDEQ doing this rulemaking now? The primary reason is because the Environmental Protection Agency has directed PDEQ to. Much of our authority and much of our direction comes from the EPA. This was two different EPA actions that we're handling at the same time because they are related. So the removal of startup shutdown malfunction affirmative defenses began as a series of legal challenges to these sorts of exemptions beginning in the early 2010s. There were a number of additional lawsuits, one of which was only resolved last year, and further EPA rules that the startup shutdown malfunction defenses to civil penalties by courts are not permissible under the Clean Air Act. So the EPA has ordered that startup shutdown malfunction affirmative defenses of the kind that Pima County has need to be removed for as regards class 1, again, that's our major sources, for federally enforceable actions. In July of 2023, the EPA issued a rule that affirmative defenses for emergency circumstances are inconsistent with the Clean Air Act and must be removed. Again, this is direction from the EPA as regards class 1 major sources for federally enforceable actions. There was an August 2024 deadline to remove them or request an extension. PDEQ requested an extension until August of 2025. So that is what we are doing right now, is trying to get everything done by August of 2025. PDEQ began removing both types of affirmative defenses from permits that have been up for renewal, consistent with EPA guidance, since August or in August of 2023. So if anybody here is connected to a source that has a permit from PDEQ, you may have noticed in a renewed permit or renewed draft of a permit that there are certain sections of code that are not there anymore. For more detailed explanations of the EPA's rules and these court cases, you can view the Notice of Proposed Rulemaking. Again, that's available at www.pima.gov/415. There are explanations and citations and links to the Federal Register notices and to the cases there. I am also happy to discuss this further with someone at any point beyond this. If people want more detailed explanations, it actually is fairly engaged and fairly complicated. We are also doing this rulemaking to maintain consistency and fairness. So the EPA direction to PDEQ is only as to the removal of the two types of affirmative defenses from Class 1 permits for federally enforceable actions. This means we could theoretically retain a complicated patchwork framework where some sources were subjected to some standards for some types of cases. We didn't want to do that. We thought that that was confusing and unfair. Additionally, these affirmative defenses have never been used. So we're trying to remain consistent. We're also trying to look at how our rules are actually used. So impacts on permitted sources. PDEQ has no record of any of these affirmative defenses ever being used. That is consistent with the EPA's findings nationwide when they did these rules updates, where they also opened for public comment but could not find examples of these actually being used. PDEQ has discretion in compliance and enforcement actions, and emissions violations rarely make it to judicial or administrative proceedings, which they'd have to be in order for an affirmative defense to be used. PDEQ's enforcement goal is always to bring sources back into compliance and to protect Pima County's air as quickly as possible. This is done through prompt investigations and letters that include opportunities for the source to respond and take measures to come back into compliance and pay fees where appropriate. If those fail, PDEQ might obtain an order of abatement, and only if all of that fails would PDEQ take a source to court. For an example of how infrequently PDEQ takes sources to court, our current compliance and enforcement manager has been in her role for 6 years. In these 6 years, she's investigated roughly 50 cases of permit violations due to emissions exceedances, and only once has any of those cases gone to court. I will add that that case also did not go to court simply because of a one-time emissions exceedance. That source had a documented several-year history of multiple types of permit violations. So it is rare to never that a source would get a chance to raise an affirmative defense in court, because where these sorts of circumstances occur, PDEQ would be very unlikely to take a source to court. We have a real world example here of an emergency circumstance and PDEQ's response. Several years ago, we had a permitted source that was operating when a sudden power outage elsewhere on the grid outside of their control caused their pollution control device to shut down, while a kiln continued to operate and the kiln could not be shut down. The source notified PDEQ immediately. PDEQ sent a letter of compliance to the source once they managed to put everything back together, documented the event, and pursued no further action. Some of this is repetitive, but it feels very important just to say PDEQ utilizes discretion at all stages of investigation and response to permit violations. Permitted sources are required to report all extenuating circumstances immediately to PDEQ. PDEQ considers all of these circumstances. We consider them in terms of how we respond. And if a case did get elevated to court, the judge would also be allowed to consider these circumstances, even without an affirmative defense rule. An affirmative defense blocks any judgment against a source. But even without that, judges still have discretion to consider mitigating circumstances. So if there was a scenario where something happened that was an emergency circumstance outside the control of the source, or there was a violation during a startup shutdown malfunction in spite of a source engaging its best efforts to maintain equipment, there is nothing preventing the source from still raising this for the judge. There is nothing preventing the judge from taking that into consideration in the fictional case in which this ever even got elevated to court, which again is very unlikely. PDEQ encourages permitted sources to become familiar with their permits and to call PDEQ the moment a question arises. The permits are very detailed. They have explanations of rules and limitations. And if there are any questions, we are the experts on this, and we are always happy to take phone calls. Impacts on people and the environment. Since these affirmative defenses have never been used in Pima County, their removal will likewise have no impact on anyone or anything that comes into contact with the air in Pima County. Rulemaking timeline. You are all at the February 4th stakeholder meeting. We have another public meeting on February 18th. That will be an oral proceeding. It is also open to the public. It is at 6 p.m. and the link for that is also on our website. The public comment period closes on February 27th. And we hope that this rulemaking makes it to the Board of Supervisors on April 1st for a vote for approval. If this is adopted, the rulemaking will go into effect on May 1st. We encourage written comments. The public comment period opened on January 13th and it closes on February 27th. There are 3 different ways to submit written comments. There is a fillable form on the website at www.pima.gov/415. You may email me, that's abigail.okrent@pima.gov. Or if you wish to submit a written comment in writing, you can do that by mailing it to our office at 33 North Stone Avenue on the 7th floor, Tucson, Arizona, 85701. PDEQ will consider all comments received. So if somebody wants to make a comment today, we will consider it. But please note that you will only get a response if you write a written comment. Additionally, PDEQ is much more likely to understand your comment correctly and archive it accurately if you submit it in writing. So feel free to make comments or raise questions today, but if you want to be absolutely certain that we got it right and that we're going to respond to you, please also submit that in writing. You have until February 27th. We have 40 minutes for questions and comments because we booked out an hour for this. Find it very unlikely we're going to use that whole time. But if anybody has a question, Sarah will now be allowing everybody to unmute. You can use the raise hand button. It's at the top of the window. It's circled in the bottom. And we'll call on you in the order that your hands are raised. And when you're done speaking, please mute yourself again and we'll lower your hand. Please speak clearly, please state your name, and please try to keep your question or comment concise. Sarah, did I miss anything?
No, I don't think so.
And if anybody is attempting to do this and failing, please again email Sarah Height, that's sarah.height@pima.gov. Does anybody have questions or comments? Okay. Well, seeing none, I want to encourage people to continue to look at our website for more information. We're also going to put these slides and possibly this presentation on the website. If you have additional questions after looking at the material available on the website and linked there, feel free to email me, abigail.okrent@pima.gov. Sarah, do you have anything else? Anybody else from PDEQ? All right. Well, thank you all so much for taking time out of your working day to be here with us. And do feel free to submit a comment or to email me if you have any questions. We're gonna end this meeting.
Okay, thanks, Abigail. Good.
Thank you, Abigail and Sarah and everybody.
Yes.